Welcome to Micro-Digressions. Hopefully, welcome back to Micro-Digressions. I'm Spencer Case, as usual, and I'm here today with Michael Huemer, who I hope needs no introduction. How are you doing today, Mike?
I'm doing great. How are you, Spencer?
Quite well, quite well.
I'm glad to be here.
I'm glad to have you here, and I'm looking forward to a discussion about legal injustices based on your book, Justice Before the Law, which I have a digital copy there. You got the physical one. So that's kind of a play on words, right? Justice before the law usually means justice according to the law, but you actually mean putting justice first, right? The law is of secondary importance compared to justice.
Yes, the purpose of the law is justice. We have law in order to try to do justice to people. So it can't be that the tool is more important than the goal for the sake of which we have that tool. So it must be more important to do justice than it is to uphold the law. Usually, you do justice by upholding the law, but sometimes not. Right? There are particular circumstances in which maybe a law is unjust, or maybe the law is just in general, but there are particular circumstances in which there would be an injustice from applying the law in this particular case. And in those cases, I think it's more important to do justice. So, like if you're on a jury and you think that punishing this defendant would be unjust for whatever reason, then you should vote to acquit the defendant. If you're a judge, then you should try to give the minimum sentence that you can give that won't be overturned by another judge, and so on. Like if you're a cop, you should not enforce unjust laws, right? You should not arrest people for doing things that aren't wrong.
Okay. Now, before we get into that, I was wondering if maybe you would want to say a bit about what law even is. When we talk about what something is the law, is it, written down in some piece of legislation and that text is the law? Or, because I guess they're like dead letter laws that aren't enforced anymore, and you can question whether those really are laws, or what do we mean by the law anyway?
Well, I mean, they're sort of like academic disputes that don't really matter practically, right? Like, oh, there's a law that's not being enforced. Does it still count as a law? Okay, that doesn't really matter. Basically, they're commands that the state is giving, right? And basically, they're enforced by threats of violence by the state. Okay. This doesn't have to always be the case. Like in theory, there could be a law that doesn't get enforced. They could have a law and like not have any penalties for it, but that would just be a strange case. Yeah. So normally there are orders given by the state that are backed up by some kind of threat of force. Sometimes it's statutory. Actually, the majority of laws in the United States are not made by the legislature. They're not made by elected officials. They're made by bureaucrats. Many people don't know this. Like when I ask students in class, what I say, actually, most laws are not made by legislators. Anyone know what they are? And, like it takes a while for anybody to come up with, they're regulations made by bureaucrats. I'm not sure if people even know that, like it's like way more. There's there's case law, which is made by judges, like, right. But all that counts, even though you think in a democratic society, all the laws should be made by elected officials, they're not.
So when you say that laws are commands of the state, does that mean the state can't make an illegal command?
Well, no, I mean, they can make commands, they can make laws that contradict other laws. So the Constitution is an unusual case of a law. It's like not a paradigm case. It's not the kind of law that you're usually thinking of, right? People talk about obeying the law, but it is also a law that's supposed to constrain the state itself. Is that a command made by the state? I don't know. It's a series of commands, I guess, made by the founders who were sort of the government at the time. So, okay. So the government can issue these commands where they are themselves violating the other commands that were given to them, to define their powers and what they're supposed to be doing with their powers.
So the reason I'm also eager to get into the practical and the applied stuff, which is really the focus of this book. But I'm raising this because a lot of people are going to have this idea that the law has a certain kind of normative force to it, even if not greater than justice. at least some kind of normative prescriptive force that we ought to take into consideration. And what it seems to me to be a traditional view is that the Constitution is like has another higher layer of authority over it. So it's not just that it's a prior command, but it is or a command about commands, but that it has a higher kind of standing or status. And talking about laws as
Yeah.
commands of the state, a lot of theorists have thought that this is a very deflationary view of what law is. Like, we invest
Mm.
law with all this kind of this moral or quasi moral significance to it. And I guess theorists are split between
Yeah.
they want to, so those who want to go say no, 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 the law is something more elevated, it has this moral significance. And then like the positivists who say no, 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 it's just a set of like practices, things that we can describe empirically. And it sounds to me like you're more drawn to that way of thinking about it.
The legal positivist, right? Yeah. 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 So there's a tradition in philosophy of law known as the natural law tradition, according to which, the law is, um, it's partly a matter of morality, right? And so, there's this famous remark from, I think, from St. Augustine that an unjust law is no law at all, something like that. Martin Luther King repeated this, when he was, I think he was, when he was engaged in civil disobedience, explaining why this was okay, because an unjust law is no law at all. Now, I kind of like the sentiment behind this, but it is not literally true. Like there are unjust laws, which are laws, like there were the fugitive slave laws in the 1800s, right? To take a pretty clear example. And like, okay, they're passed by the legislature, they're on the law books, they're getting enforced by the courts and the police, and like seems like those are laws, and they were unjust, right? But I don't want to say that morality has nothing to do with the law, right? So one thing is sometimes the law is kind of ambiguous, and so like it has to be interpreted, and it's reasonable to interpret it in accordance with moral values. Also, sometimes the law actually uses moral terms or evaluative terms more broadly. So there's a prohibition on unreasonable searches and seizures. Okay, what's unreasonable? Unreasonable is a value judgment, right? And so that like your judgments about morality and justice can go into what you consider unreasonable. And therefore they go into what the law actually requires. So that's all fine. But, like you can't plausibly have an interpretation of law where no laws are unjust. Like, okay, so like I'm not saying that justice and morality have nothing to do with the content of the law. I'm just saying that they're not so tightly connected that it's impossible for law to be unjust.
All right, so I'm sure you're familiar with this case that we discussed in the law and legal theory class that I taught this semester, the Riggs v. Palmer. This is like a New York State case from the 18th century, not a Supreme Court case, where this guy had murdered his grandfather when he suspected his grandfather was going to remove him from the will. And
Right.
they determined that for moral reasons, he wasn't legally entitled to the inheritance. And so that would be a case where a moral principle that you should not benefit from your wrongdoing is impacting the interpretation of what, in fact, the law is, even though if you just go by the letter of the law, it seems like he'd be entitled to it.
Yeah, good. Well, okay, so this kind of brings up the idea of the common law, right? Because yeah, in our tradition, there's this thing called the common law where people attempt to, um, I mean, it's frequently described as judge-made law. But when the judges are making this common law, they're not trying to just like come up with whatever rules they want or they believe should exist, right? They're sort of trying to capture the norms of the community. That's what it's supposed to be. So there is this other notion or this other kind of law. So there's legislative law where the politicians write something down and whatever, and there's regulatory law where the bureaucrats write something down. Okay, and there's also judge-made law, like case law. But then there is this other thing where there's just social conventions. There are some things that you're supposed to do and some things you're not supposed to do in a particular society, and like those could be thought of as laws. That's reasonable. So, and that is what the judges are trying to capture. They don't necessarily always succeed. Okay. So there could be common law that doesn't correspond the moral sense of the community, but it usually does. When you read these common law decisions, it usually does seem very commonsensical. Okay, so like that is a good example. There's this sort of common law doctrine that you shouldn't be able to profit from a crime or something like that, which they cited. And then you think, yeah, so like there wasn't a statute that actually said that you couldn't inherit money as a result of murdering the person that you were going to inherit it from. But they just thought, yeah, no, like in our community, that wouldn't be considered acceptable. That seems kind of reasonable. That's reasonable to me.
All right. Well, I could press you further on this legal theory, but I think we're both eager to get to the applied matters. So let's go straight into plea bargaining, which is an issue I really hadn't thought a lot about before reading your very
Yeah.
interesting chapter in this book. And it turns out there's some pretty compelling arguments against it. So why don't you explain what plea bargaining is and why you think
Yeah.
it's a bad thing that should be limited?
Well, yeah, I'm under the impression that most people do not know how our justice system works. And I have very little idea, like when you watch TV shows in which there's a case, like it always goes to a trial. And actually, that's not how our system works. And you hear, like in your high school civics classes, you were taught that everyone has the right to a trial by jury. And so you think, oh, so that must be true. And in a way, it's not really true. Right. So something like 97% of cases get resolved by plea bargain. It's just like a huge majority. And this is
That figure
where,
blew my mind. When I read that, I was like,
mm,
"What? What else do I not know about my country?
yeah,
My God!" Like I knew plea bargaining was a thing, but if somebody asked me to say, "What's a figure? How many cases? What percentage of cases do you think go to trial?" I would have thought most of them. No.
yeah, yeah, hardly any. And this is where, and why? Because it's cheaper to plea bargain. It costs the government money and the courts are always backlogged. So the prosecutor offers a deal. And there are two ways of describing this. One is they offer a reduced sentence or reduced charges in exchange for your waiving your right to a trial. The other way of describing it is they threaten you with additional charges or a heavier sentence if you insist on your right to a trial. Those are logically equivalent. So if you don't think that they should be able to threaten you with a heavier sentence for asking for a trial, you should not think that they should be allowed to offer you a lighter sentence for waiving the right to a trial, right? Also, I think most people are unaware of how big the difference is. So, on average, you get a 3 times higher sentence if you go to trial than the sentence that you would have gotten by plea bargaining. So, that is enough that's enough to make it rational to accept the plea, even if you think you probably would have been acquitted at trial. So, if you think that there's a 60% chance that you'd be acquitted at trial, you should still plead guilty, right? Prudentially. Maybe in some other sense you shouldn't, but like in the prudential sense. So, okay, so we're giving people incentives to take punishment when they probably would have been acquitted. That seems like totally bogus.
By the way, it just
Yeah.
occurs to me now that this seems like if a case does go to trial, given that we have this plea bargaining system, that's at least some reason to doubt that the person should be convicted, that they thought that they should take this to trial.
Right.
And maybe that the lawyers went along with it. That's at least some
Yeah.
evidence. It's not like dispositive, but the
Yeah.
fact they wanted to fight it out.
The defendant thought that they had a good chance of winning, although the lawyer probably told the defendant to take the plea, which they usually do. By the way, after cases go to trial, they're usually convicted. So it's something like 90% of trials end in conviction. Right? So like almost everyone who gets into the criminal justice system gets convicted. You might think this sounds bad, like, oh, is that because the system is ridiculously biased? It could be, or it could be because actually almost all those people are guilty, which is what you would hope, right? Because like going through this process that's an ordeal for anyone. So we should hope that we're not putting a bunch of innocent people through this ordeal, even if they eventually get acquitted, right? So it should be that they only prosecute people if there's really strong evidence. And maybe that's why almost all the cases get conviction.
Prosecutors, yeah, they're incentivized. Like you want to have the best win record, right? So presumably you wouldn't want to take it to trial if you didn't think you were very likely to win the case. But I
Yeah,
wonder,
yeah.
is this a thing that they can do where like give a plea bargain and then the defendant doesn't accept it, and then they're like, "Oh shit, maybe we just ought to drop charges because we don't want to take this to trial." Is that a thing that happens or could happen?
Yeah, I mean, that could happen. I don't know how often that happens. See, like, I'm not actually in the system. I've only read about it. Like, I have not worked at a lawyer as a lawyer or anything like that. I think my general sense is that prosecutors have this, so they have this adversarial view, and they view themselves as advocates for prosecution. And so basically, they view themselves as the enemies of the defendant and their job as causing as much harm as possible to the defendants. And then if the defendant refuses to take a plea bargain, the prosecutor might get mad because he wanted to get an easy conviction. That's the easiest, cheapest way to get a conviction. So then he might just like go extra hard against that defendant and just like put him through all of this trouble to punish him, for being a jerk by insisting on his rights and costing the government money. Like, I think there's a legitimate moral reason why you should plead guilty if you are guilty. Like, if you are guilty and you plead not guilty, then you're imposing costs, unjustified costs on the state because they have to do this trial, and you're attempting to get away with your crime, both of which are wrong. So it's not really an injustice that you get a heavier penalty after getting convicted at trial than if you had admitted to your crime. But it is an injustice that it's 3 times heavier. Like, if it was 20% heavier, yeah, maybe that would be okay. Maybe that would be right, but not, 300%.
Yeah, so this strikes me as one of the most plausible proposals for reform in the book, which is that we don't completely get rid of the trial penalty and plea bargaining, but we limit the trial penalty so it just an innocent person is not going to waive the right to a trial, and
Yeah, yeah, that's right.
so
Yeah,
that seems like a
yeah,
really, and so hopefully, because the worry about getting rid of it is that now you have, if it's 3% of cases are going to trial, and you know we might have 30 times as many trials, which would be really difficult to deal
yeah,
with. So you want to
yeah.
hit the right balance where innocent people are going to insist on going to trial, but guilty people won't.
That's right. Yeah. My recollection is that in Britain, there's a limit on the trial penalty, which is something like 20 or 25%. I've forgotten. But, it did not cause a complete collapse. You know, their justice system is still working. I mentioned in the book that there was an academic study to see if you could get people to admit to a crime they didn't commit, by conditions that are similar to what we do in the justice system. And the answer is yes, you can. So they had this whatever the study in which people were taking a test, and then basically the subject would get accused of cheating on the test when the experimenter knows for certain that they did not cheat. But then they would describe, okay, well, you can just admit that you did it, and then we'll give you a minor penalty, or you can, get you can get this adjudicated, whatever, go to the academic equivalent of a trial, and then there will be a much heavier penalty if you're found guilty. And then they find that you can get the majority of people to admit to having done something that the experimenter knows for certain they didn't do. So this is like, yeah, that's not really surprising. Like, there is self interest. If you didn't do the thing, you don't want to say that you did it, but you also don't want to have like a 3 times heavier penalty. And you should not rationally have total confidence that the trial is going to have the correct outcome. Even if you know you didn't do it, that doesn't mean that you won't be convicted. Innocent people have been convicted. That has happened many times.
Now I'm wondering, um, did they do this experiment multiple times under different conditions to try to see what the punishment ratio is, um, like the penalty to benefit ratio, to see like, because if it was only a small penalty, the people who didn't cheat would say like, no, I'm not
Yeah,
doing
I
it.
think
No.
yeah. I think not. So I only recall one study. So I don't, and it would be desirable to have multiple replications and such. Although the conclusion here is just like independently plausible. You know, just as an aside, like a lot of psychology results turn out not to replicate, right? It's something that has come out in the last 10 years. A lot of things that the psychologists discovered in their studies, and somebody redoes the study and like they can't get the same results. So, but the things that don't replicate are typically the amazing things, not the common sense things. And it's kind of common sense that you could get people to just like act in their self-interest in this case. So I think it's true. There are cases of, there are many cases of people getting exonerated, and some of them involve people who pled guilty, right? Because they thought that they were going to be convicted even though they were innocent.
You've got some great arguments about plea bargaining as extortion. You've got that argument, and then you've got arguments that it violates the Fifth and Sixth Amendment, which were both novel to me. I thought they were pretty persuasive. So let's
Yeah.
hear those arguments.
Yeah. So there's a prohibition in the Constitution on being forced to testify against yourself. There's also a provision in the Constitution that you have the right to a trial by jury, which is mentioned a few times. Like it was super important to the framers. So, well, a plea bargain is a coerced guilty plea, right? So, as I was saying at the beginning, well, saying you'll get a lower sentence if you take the plea bargain is equivalent to saying you'll get a higher sentence if you refuse it, i.e., you'll get a higher sentence if you insist on a trial. And there's Supreme Court precedent indicating that, well, the government cannot place burdens on people for exercising constitutional rights. Like you can't have a cost imposed on you for exercising something that is your constitutional right. So, okay, if a prosecutor said, if you have to give up your right to trial, otherwise I'm going to beat the shit out of you. The prosecutor said that would clearly be a violation of the right to trial by jury. So, okay, well, if he says, yeah, take the plea bargain, otherwise I'm going to add additional charges against you, or I'm going to request a much heavier sentence for you. Okay, I'm going to give you, instead of manslaughter, I'm going to give you a murder charge or whatever. Like any of those things, like that's way worse than beating the shit out of you. That is a lot more harmful. So like that's if the beating the person up counts as coercive, then threatening to add charges or make more serious charges counts as coercion. Okay. The other thing is, if you take the plea bargain, you have to testify against yourself in court. That's what it is. You have to go to the court, you have to go to the judge and say, yep, I did this thing. I did this crime. Because that's what a guilty plea is. So you're being forced to testify against yourself, right? In addition to being forced to give up your right to trial by jury. So those are both prohibited by the Constitution.
Yeah, that's interesting. The argument that you haven't, yeah, you have, it's of course giving up of a constitutional Bill of Rights, right? Yeah. So it's interesting. You had I thought another argument too about certain rights being inalienable. So like you could not give them up because they served a social function. Was that in
Right.
connection with plea
Right.
bargaining?
Right. Yeah. There's somebody who said, well, it's in the interests of the defendant to take the plea bargain, because if it wasn't in his interest, he wouldn't take it. All these people are taking plea bargains, so they must think that they're better off. So, like they would waive their right to not be coerced into taking the plea bargain, right? And then my argument was, well, you shouldn't be allowed to waive just any right. Okay, so like this is an analogy. Imagine, um, the government has some information, like maybe the New York Times wants to publish some information about government malfeasance, and the government doesn't want it published. Okay, but the government can't prohibit the New York Times from publishing this because First Amendment. But imagine the government goes to the New York Times and says, okay, we're going to pay you $1 billion to not publish this. What do you think? And it's in the interest of the New York Times to take the $1 billion. Should they be allowed to do that? And then my claim is no, they should not be allowed to waive the right, of freedom of press in exchange for money from the government, even though it's in their interest to do so. Because the point of the right of freedom of press is not to further the interests of the press companies. It's for the interests of the public to have the press, publish whatever information they have. Okay. And so similarly, well, it's in the reason for the right to trial by jury is not just like to serve the interests of defendants. It's to serve the interests of justice because we think that a trial is the best way of finding out what really happened, whether or not that's what the defendant wants. So, like if the defendant is guilty, then it's in the interest of justice to find that out, to find out that he's guilty and then have him get punished. And it might be in his interest to, make some deal where he will get a lower punishment than the one that is prescribed for the thing that he actually did, but he shouldn't be able to make a decision that would make that happen because it's unjust.
Okay, so this is the one argument in that chapter I'm not so sure about. It's interesting, but I'm not totally convinced. And I guess it's partly a matter of I'd like to hear an account of which rights you can waive and which ones you can't. I'd like to hear a complete account of that. Principle, it seems like this is a view you could have that your rights are about your autonomy. They issue from your right to control yourself, your body, your mind in certain ways. And if that's the case, it's not clear why you wouldn't be able to waive some of them. And it seems like the freedom of speech, it seems like you can waive your freedom of speech. You can sign a non-disclosure agreement. You can give away your right to talk about certain things.
Yes.
And it seems to me that you're committing yourself to a really consequentialist account of rights here that is, I think, at variance with some of our intuitions about rights. And it seems like I'd like to hear more of an
Yeah.
account of what you think rights are and what their foundation is.
Oh, okay. Yeah. I mean, there's sort of natural moral rights and then there's legal rights. Some of the rights that are in the Constitution are there not so much because of the natural rights of the individuals, but yeah, they're there for kind of rule consequentialist reasons, not act consequentialist, right? But they're there because the rule that recognizes that right is beneficial to society. That's the case with the freedom of speech and freedom of the press, right? I mean, there is a natural individual right to speak freely. Okay. And so like there is a natural individual right on the part of the people who own the New York Times to publish things that they want, provided that what they're publishing isn't violating somebody else's rights. But that's not why freedom of the press is important. Right? Like if that was just it, then it would be, on along the lines of the right to drive a car, the right to walk to work or whatever. Like it wouldn't have this place as like the First Amendment and this thing that we have all this jurisprudence about and all of this concern about protecting. It's only because of the importance to society. Now, okay, what do we think about this kind of rule consequentialist approach? I mean, I have some sympathy for rule utilitarianism more generally. Okay, but okay, well, we don't have to. You don't have to take a general rule utilitarian view. Like, if you agree that freedom of speech and freedom of the press is super important, like, then you should be able to just think about, well, why is that really important? Because, like, for the individual, it's not very important. So, like, I feel like criticizing the government, but if I don't, it's not a big deal to me. Like, there's a lot of things that are much bigger deals to me. Like, I should have a right to have a one-bedroom apartment. Like, that might be more important to me than the right to criticize the government. So, if we think that this is important, it's got to be for this other reason because it's important to society to have that rule. So, okay, now, okay, well, what's the general account of which rights you can waive? You're like, I don't have a list, right? But basically what you should do is if there's a particular right and especially if it's in the Constitution, you should think about why it's important. And like usually the reason why it was important was that it had something to do with protecting against the government becoming tyrannical, right? Which is good for society in general. I mean, protecting against that is good for society in general. And that's why the framers put that in there, right? Okay, so if that's the case, if you conclude that, yeah, the reason why this was important was to protect society in general from tyrannical government, then that's one of those things that the government shouldn't be able to just like get you to waive. Maybe you should be able to waive it for other reasons, but not because the government is trying to get you to waive it, because the government is giving you incentives to waive it, right?
Okay, so in a variation of your New York Times case, if I'm just some dude and you're the editor of the New York Times and I know that I have a lot of money and I know a really unflattering story about me is about to drop, a true story for that matter, I can pay you $1 million for you to quash the story. That wouldn't be I wouldn't be giving up your freedom of speech in that case. But if the government does it, then that would be an injustice.
Yeah. I mean, would I be giving? I'd be waiving my right to freedom of speech. Should that contract be prohibited? I guess I would say not. This is like before the whatever it was, the 2016 election, when Trump had to pay off Stormy Daniels, or not had to, but he did pay off Stormy Daniels to keep this story about an extramarital affair out of the press. Yeah, but, like, it wasn't the government who was trying to get this story removed. He wasn't in the government yet. So I would think that would be a legitimate contract. Okay, but so my claim isn't actually, so when I say that you shouldn't be allowed to waive it, I don't mean that you've done something wrong if you make this deal. I mean the government has done something wrong. So actually, so that was a misstatement, right? Like, actually, I should say the government shouldn't be allowed to incentivize you to waive it, right? By threatening to do stuff to you if you
But
don't waive it.
everyone else can, right? Because Trump was, on your view, he can pay Stormy Daniels. That's an okay transaction. In this hypothetical where you're the editor of New York Times, I can pay you not to publish the story. But I thought your whole view was about treating the government as equivalent, as just any other actor. So if any other actor can do this, I don't see why the government couldn't do this.
Oh, well, I mean, is the government just like any other actor? Well, it depends on the context. So, if the reason for the constitutional right was to protect against the government, then the government should not be able to undermine that right. And the reason for the constitutional right was not to protect against people like Stormy Daniels. Okay, and why? Why do we need more? Why do we have like protection against the government that we don't have against Stormy Daniels? Right? People like that. Government is a bigger threat, right? Because if we don't have that protection, then the government might become tyrannical and um, send us to concentration camps, whatever, create famines that kill millions of people, whatever, stuff that happens when the government becomes tyrannical. That doesn't happen if Stormy Daniels, whatever, gets too much power.
I see your point. But my mind is just snagging on this thought that if something is truly my right, I ought to be able to dispose of it as I please. And it seems odd that when you say the reason for the right, like the reason for the constitutional enshrinement of the right might be for this public, it might serve this public purpose, the civic purpose of constraining government. But it seems like the actual ground of the right is something different. It's something about the nature of me as an agent, with God-given rights or whatever. And it doesn't derive from the fact that there's some useful public.
I mean, some rights are like that. Some rights are just, natural rights, natural individual rights, because of whatever human nature and your nature as a rational being. But not all are. So that now the right to free speech is a little complex because, as I say, I think, well, there is a natural right to free speech. It's just that it's a relatively unimportant one considered as such. And it's just like more important as this kind of instrumental whatever rule utilitarian thing. Okay, but there are some rights that I think you would agree are not just like natural individual rights based on the nature of humanity. So there's a right to vote, right? What if the government decides to just like, so it's not a natural right independent of the government. What if the government decides to start paying certain people not to vote? And and they voluntarily sell their right to vote.
Jason Brennan,
Okay.
I think, has a paper defending this practice, this
Okay.
hypothetically. Uh,
Yeah. Yeah.
he said, why
So,
not?
what about, what if, the Trump administration creates a fund for paying Democrats not to vote? And,
I mean, we've spent
you
government
know,
money on worse things, I have to say.
yeah, yeah. But, or, okay, sorry, better example, a Democrat comes up with a fund to pay Republicans not to
I don't
vote.
like this. I don't like this. This should not be allowed.
Yeah. So, like whoever's in power, then they could just use it. And like a bunch of people would sell their right to vote. Because like, how much is it worth? Like, how much is it worth to you to get to vote? Oh, I have a 1 in 10 million chance of changing the outcome of the election. So if I live for 40 million years, one time I'll probably change the outcome of an election. Okay. I'm not gonna live long enough for this to ever pay off. So yeah, I might as well sell it.
By the
So
way, and I had this experience moving from Bowling Green to Tucson last year. We had a very horrendous moving company, which is 777 movers, these guys, where they damaged $1,000 worth of equipment, or worth of our stuff, right? And didn't want to pay us any kind of compensation. Were rude to my wife over the phone. May sent them a message saying, okay, I'm going to write a 1-star review now. They immediately followed up and offered us like $237 and said specifically, if you don't write a review, we'll give you this fraction of what we owe you back. And we said, nah, you keep your $237. You're getting your 1-star review. It's worth it to us to
Yeah.
give you the finger for how terrible this service has been. So
Yeah.
I think it would be similar if there was buying in, voting and stuff. Like certain people
Yeah.
would pay, or would take
Yeah.
the payment, but
Well,
others would.
in that case, I think you'd be justified in taking the money and then posting the review anyway after you get the money because they can't get it
But other
back.
other people have done it, and they said, "Oh, but here's your agreement not to post a review because we settled this, right?" So they get on the review sites and they show the agreement that, so they're doing this at scale.
Yeah. Yeah. Um, but oh yeah, okay, yeah. So some people would refuse to sell their right to vote. People who love voting, but a bunch of people would do it. So like maybe the government gets 1 million people, 1 million Republicans to not vote, and that swings the outcome of the election. And they could keep doing this so that they stay in power. This would be a problem. Then this could convert the country into a one party democracy, otherwise known as a dictatorship. And so, yeah, okay. So the government should not be allowed to do that.
It seems very plausible that the government should not be allowed to do that. And actually, to your point, it does seem like the right to a trial by jury is more fundamental. Like if I had to give up one of my rights, I was going to be stripped
Yeah.
of one of my rights permanently. The right to vote or the right to have a trial, if I'm accused of something. Obviously, you give
Yeah.
up your right to vote. It's obviously less important.
Yeah.
It's like not
That's right.
not
Yeah.
even close. Not even close.
Well, yeah, that's important to you. Although, well, this is, of course, assuming that you are innocent. If you're guilty, then, maybe you don't want a trial. Okay. But, oh, yeah, but which one is more important to society? Well, yeah, if it's just one person, maybe the right to the trial is more important. I don't know. But, like, if it's millions of people, yeah, maybe it's worse for society if millions of people give up the right to vote. Anyway, okay, but the point being, like, the reason why the government wouldn't be allowed to do this is something about the effects on society as a whole of having that rule, even though it would be in the interest of the individual who's giving up their right to vote. It wouldn't be in the interest of society to have that be allowed. So it's not allowed.
I see. Um, yeah, it's very interesting. It's very interesting. I worry though, wouldn't that mean that you couldn't even have a limited role for plea bargaining? Which your very reasonable reform of just capping it. Um, why wouldn't this argument rule that out too, right?
Yeah. I mean, like it may be that we should completely get rid of it. Like I'm not totally against that conclusion, but I think that the way to defend limited plea bargaining is to say, well, it's not really coercive. So you can't coerce somebody to give up their right to trial or any other constitutional right, but it's not really coercive if it's just like a 20% increase, right? Also, it's not an injustice to get a heavier sentence because you went to trial, because actually it is wrong. It is actually morally wrong to insist on a trial and attempt to get yourself acquitted of something that you know that you're guilty of. Okay, and whatever. This is not like a wrong that a lot of people think about, and like it's not the main wrong that the criminal did. When you commit a crime, the crime is the main wrong, not trying to get away with it. Trying to get away with it is also wrong. So, okay, yeah, and it's plausible that it could be 20% more wrong, and also plausible that the 20% increase in the penalty would not actually cause an innocent person to plead guilty. So on balance, it's like, yeah, this seems a lot more defensible. A lot more defensible than having the penalty multiplied by 3.
That seems right. I don't know that why, like, even if it's 20%, like a year in prison is a year. Like, I don't know why the percentage of
Mm.
should matter in terms of determining whether it's coercive or not. Like, like
Yeah,
consider the torture analog. Like, if you were threatened with like 20% more torture, if
yeah,
that seems like it's coercive. That it, you
right.
know. That's like,
Well, yeah, so maybe it should be an absolute amount. Maybe the limit should be some absolute increase in the penalty. Oh,
yeah.
yeah, that could be.
But then, yeah, but then it's hard to see what that absolute amount would be, that would be appropriate for any kind of.
Yeah. Well, like so, I mean, one of the arguments is that you don't want to incentivize people to plead guilty when they're innocent. Right. So so that argument does connect up with the percentage penalty. And that does also have a basis in Supreme Court, whatever precedent. Because one of the cases in which like plea bargaining was upheld, the majority opinion says this stuff where like, obviously we wouldn't want to have plea bargaining in cases where you're incentivizing innocent people to plead guilty. Obviously we wouldn't want that. But don't worry, that's not happening here. Okay, but we now have the situation where like, after they made that decision, the practice just expanded dramatically, right? And the differences in punishment that people get expanded. And so now it really is the thing that they said that we obviously wouldn't want.
One of the things that comes up in your book is a lot of the worst parts of our legal system are not deeply embedded in our legal tradition, but are like recent innovations. Like 100 years ago, or maybe a little bit more than that, plea bargaining was highly frowned upon, and then they just
Yeah,
got kind of used to it, and the tradition against plea bargaining, the anti-plea bargaining norms just kind of dropped out.
that's right. Yeah. Yeah, it was originally, I think I quoted some, now I've forgotten who this was I quoted, but yeah, there was some older legal source saying that like you should only accept a guilty plea if it was made in the knowledge that there would be no reduction in the sentence. They didn't want people pleading guilty because they were expecting leniency. And you could see why someone would think that, right? Because yeah, they should only be pleading guilty because they recognize their guilt and they're ready to take the consequences for what they did. They shouldn't be trying to get an advantage because obviously that would incentivize people to falsely plead guilty. Mm.
Does it also take away something morally from the confession that it's done out of self-interest? It seems to. Maybe
Um,
that
yeah,
maybe that's not something the state should be super concerned about, but it does seem
yeah,
true that a confession that is to buy leniency doesn't seem like it's coming from an apologetic place necessarily.
that's right. Yeah. I mean, yeah, obviously, morally speaking, if you're doing virtue theory, it's better if the person confesses because they feel bad about what they did. But I would guess that that virtually never happens because, well, the person who is going to commit the crime is not the sort of person who would voluntarily accept punishment. Like it takes more moral character to come clean about having done something wrong and accept the punishment voluntarily than it does to not do the wrong thing in the first place. So there's going to be hardly any cases. Also, by the way, but yeah, like it would be better, but that's not like super important. The main thing that we care about is just like getting the guilty get punished and having the innocent not get punished.
Yeah. So you say you accept this view. I guess I accept this too, but I was thinking today, like, why do I believe that? Do I have a good grounds for that? It's worse to punish an innocent person than not punish a guilty person. So that's why the burden of proof is on the prosecution rather than the defense. That seems right to me. And it seems right for all sorts of institutional reasons that it would be better that the state has to prove their case for punishing people. But is it a basic fact about morality that it's better to punish or to not punish a guilty person than to punish an innocent person? Does that just rest on
Yeah.
an intuition, or is there some more general principle here that's built on?
Yeah. Um, Well, a couple of things to say, like, yeah, there's an intuition. Like, you tell the story about, this is one of the stories in the ethics literature, right? Like, there's been this crime that has caused public outrage. And so there are going to be riots if nobody is punished for the crime. And the sheriff can't find the actual criminal, but he could frame an innocent person, which will cause that person to be punished, but that will prevent the riots by the mobs. Okay. And assume that the riots would cause more rights violations. And like, so like during the course of the riots, some innocent people will be hurt unjustly, and the harm to them is going to be greater than the harm to this innocent person if he gets punished. So, okay. And then almost everyone has the intuition that you can't do that. Okay. So, and why? Because there's a right not to be wrongfully punished. Okay, but what about if you fail to punish a guilty person? Well, if you fail to punish a guilty person, that's not really a rights violation. Like, it's good to punish the guilty person, but like, there wasn't anybody who had the right that you do that. If you fail to punish the guilty person because you don't know who's guilty, then you didn't violate any rights, right? So, like, this is just an instant.
Does the public have a right that dangerous people be incapacitated and evil actions be deterred by the state? I know maybe that the state doesn't think of it this way, but on any plausible attempt to justify the state, that's what the state should be doing. If it should be doing
Yeah,
anything,
yeah.
don't we have a right for them to do that?
Well, I mean, we have a right for them to make a reasonable effort to do that, but we can't have a right that they succeed, given that it's hard. So, and particularly if they don't know, right? They don't know whether a particular person did it. They won't be violating anyone's rights by not punishing that person because they don't know that he did it, right? Okay, so like, oh, well, what if it's like 50% probable? No, 60% probable that this person did it, and they're not punishing because they're not sure that he did it. Then did they violate anyone's rights? No, but they would have violated somebody's rights if the reason they don't know is that they didn't investigate. It's like, yeah, we could have a right that they make a serious investigation and try hard to find out who did it. We could have that.
But I'm thinking like juxtapose a serious non-punishment with the kind of case you were describing, which is the serious punishing of the innocent person.
Yeah.
Punishing an innocent person, let's say with 5 years prison time to stop the riot. Maybe that's enough to stop the riot versus not punishing Ted Bundy or something like that. Maybe the
Yeah.
second thing is the more serious wrong to the public.
Yeah. Well, that's because we know that Ted Bundy is
Well, let's say they're 60% sure he's guilty.
right. Yeah. Good. Yeah. So then there'll be this chance that, well, okay, like if he doesn't get punished, there will be some more rights violations, but there'll be Ted Bundy's rights violations, not the government's rights violations, right? Okay. But then you think, oh, but yeah, but it'll sort of be violations by the government because it was their responsibility to protect us, right? But it's sort of like it's a different kind of right. Like my right to be protected by the state is if you believe in this sort of thing, it's sort of like a contractual obligation. Like we're paying them to do it. That's why they have to do it. Right. But my right to not be unjustly punished, like not to have somebody kidnap me and throw me in jail, like it has a stronger basis, right? Like that's a natural right. So and it can't really be overcome by somebody paying someone, right? Paying somebody to do the thing they have the right against.
Well, I would have thought the basis would have been something like my dependent relationship. Like I depend on the state for my rights to be protected in a certain way. And it's similar in a way that's analogous to the way my children depend on me to be a provider. It's not
Yeah.
contractual.
Well, I mean, I'm not sure this is true. You're dependent on the state. Like, no, you can protect yourself. What do you mean? You buy a gun. Eh, well, so you might, yeah, okay. So it's kind of like, oh, well, what if I hired a security guard company to protect me, and then I'm dependent on them to protect me? Yes, but only because I decided to use that as my method of protection, right? Okay. Then you might think, oh, but wait, this is a stronger point. Maybe the government is actually preventing you from protecting yourself, and then they would acquire a particularly strong duty to protect you, right? So, like, I think that's true, but I mean, obviously, I don't think that they should be preventing you from protecting yourself. There's some ways in which they are, like gun control laws, right? Which obviously they shouldn't be doing.
Well, I mean, even if I'm armed to the teeth and have a good security system and all of that, if the state is just like failing to maintain order in a way that there's rampant criminality, I'm not going to be safe. And I will likely
Yeah,
not succeed in protecting my family for more than a very limited period of time under those circumstances. So it seems like
yeah,
even if I have some ability to protect myself, it's going to be so limited and so dependent. Like I can defend myself from one person, like on a particular occasion, but
Yeah,
not from a state of thoroughgoing
yeah,
disorder where the state isn't.
right. The Hobbesian
Yeah,
jungle. But I mean, like if the state is failing to provide order in general, and I don't know, there's a high crime rate, or maybe there's like this Hobbesian war of all against all. Like, well, why is that a rights violation by the state as opposed to anyone else? Because nobody else is providing order either. So, like, why wouldn't you say, oh, everybody's violating your rights by not providing order?
yeah, right. I mean, I guess it's because in the Hobbesian state situation where the state isn't established, you can't really accuse the state of anything.
Right.
But now,
Yeah.
now that I have come to depend on the state as the provider of that order,
Yeah.
now I am in a relationship of dependence on them to provide it. I think it's something like that.
I mean, like, why isn't this like you're saying that you're dependent on farmers for food, so you have a right for them to feed you, right? It's just like, yeah, they're people who are providing a valuable service. Yeah, you always depend upon whoever's providing a service. I mean, I think there is a difference if they're actively stopping you from getting it from in other ways or from other sources. So, which farmers usually are not. Okay, but maybe there's a point that the state is actively stopping you from getting protection in other ways.
Farmers also don't coerce me and justify
Yeah,
it based on the food. They don't think that they give me a
they don't force you to buy their
right. The
food. Yeah,
government forces me to buy this order.
yeah, right. But I mean, that's sort of like that doesn't speak to the dependence point because you're equally dependent on both of them, even though one of them is more coercive. But okay, yeah. So the thing is like, well, the government is forcing you to pay for their protection services. And like this is like a libertarian anarchist point. They're preventing you from buying protection services from any other agency. They're preventing any competing protection agency from even forming, right? Which if there were some, you could buy protection from them. But okay, so you can't because the government won't allow them to exist. So then they're obligated to do it. Um, yeah, and then what do we think about that? Oh, but still, like that doesn't create as strong of an obligation, right? So like I could create an obligation in myself to do something for you, and it will generally not be strong enough to overcome pre-existing natural rights that other people have. So, like, if I harm you, I would have an obligation to compensate you. And suppose the only way for me to compensate you is to steal the money from someone else. Oh, I can't do that, even though I have a strong obligation to compensate you. Right?
All right. So I wanted to talk to you about a couple of issues that I think are interrelated, and that's your thoughts on jury nullification, what that is and why you favor it, and the kind of anti-institutionalism that partly is what leads you to this view, which is just the more general view that we ought to be aiming for justice in whatever our role is, rather than performing some more limited institutional role as the juror.
Yeah. I mean, um, I do want to say that my understanding of the point of a jury trial, as the framers envisioned it, included that they should have, the right to jury nullification. That is part of the function. That is part of the design of that institution. That's why we have it, so that the jury can exercise their own independent moral judgment. Right now, so like in the United States, jury nullification is completely in line with the design of the institution. If you were in a different country where I don't know, like somehow they had a jury trial, but it didn't have that function, and the framers of your constitution were like tyrants, and they said some other thing, um, maybe then you should still do the jury nullification. Okay, but like the case is particularly strong in the United States. Okay, so anyway, yeah, what is this jury nullification thing? It's when the jury in a trial votes to acquit the defendant because they think that there would be some kind of injustice if they convicted the defendant. So this could be because they think the law itself is unjust, or it could be because they think, sometimes they think like the defendant has already suffered enough. They might think that the punishment that goes with that crime is excessive. So there'll be cases where like, somebody gets 20 years for possessing marijuana or something crazy like that, if you're in Louisiana or someplace like that. Or it could be that that you generally agree with the law, but you just think that in this particular case, there are unusual circumstances that make it unjust to punish this person. And then they vote to acquit. So voting to acquit for reasons other than that you don't think the person did it or it wasn't proven that they did it. Right. That's jury nullification. This has happened many times. The jury usually doesn't actually say that, and they don't get questioned about it either. Like after they give the verdict, they don't have to explain why they gave that verdict. So we don't really know, but there probably have been a lot of cases of jury nullification. So like there was the case where Jack Kevorkian got acquitted, I think maybe 2 or 3 times for assisted suicide. And there's zero doubt that he did it, right? Like he was very open about that he assisted people in ending their lives. These would be like terminally ill people. And then in some states, it was illegal for the physician to help them end their lives. And he did it anyway. And he got acquitted a few times. And then whatever, he got convicted the 3rd or 4th time or something. So, okay. So that was almost certainly during nullification. During the era of the fugitive slave laws, during the slavery era, frequently people would get acquitted for helping runaway slaves or for failing to turn in runaway slaves, right? Because you were legally required to turn in the runaway slaves. People would get acquitted for that mysteriously because juries just didn't think that should be a crime. Sometimes people get acquitted for drug charges today where, it might be because there's widespread opposition to the drug laws.
So I guess my thought here about jury nullification is, doesn't it come down to just a purely empirical, I guess it's not totally empirical because it's about something normative, but it's just based on thinking that the subjective sense of what's right and wrong by the average person on the jury is going to beat the objective apparatus of the state and the adversarial justice system and all of that. If it turned out that people were nullifying laws that were good laws, like if that would happen super often, then it seems like, well, then we shouldn't have it, right? So
Yeah,
if it turned
well,
out that like a norm of jury nullification, what that would mean in practice was that people would say, okay, I'm not going to convict somebody of my race or something like that. Then
right, yeah,
and it would see and if there was a sort of a ubiquitous temptation to do that kind of thing that made enough of a difference, it would seem like, well, maybe that would show that jurors should have a more limited role in just determining facts.
yeah. I mean, bear in mind that in this hypothetical, you're in an extremely racist society. So why wouldn't the judges and the legislators also be racist? And it's a democratic society, so they would probably elect racist legislators and judges. So that's to say that your scenario is an unlikely scenario where right, because it has to be that the judges are not racist. Okay, but I wanted to say there are two separate questions. And when you tell lawyers or people familiar with the justice system about the jury nullification, they're often bizarrely incapable of entertaining one of the questions. So one question is about institutional design or what the general rules should be. Another question is about individual ethics, what you should do if you are on a jury. Okay. And the second one is the one that it's almost impossible to get lawyers to consider. Like when you say, yeah, well, then I think that you should vote on the basis of your judgment of what's just. And then they say, oh, but what if everyone? No, I'm not saying anything about everyone. I'm not saying what the rules should be. I'm just saying you happen to be in this jury with the system as it actually is in reality right now. What should you do? You're not deciding what the rules should be. You're not deciding what the judges should tell anyone. You're not deciding what the Constitution should say or anything like that. You're only deciding what you should do. Okay, so what you should do is what you think is most just, right? It's hard to see an argument against that. Okay, but there is also an interesting question like, what is a good design for a system? Should we have the right to trial by jury? Right. And basically, I think, the only reason why we would want to have jury trial is so that we could have jury nullification. That's the only reason for having it. So what are the functions that that we might think that the jury would have? Okay, judging the factual evidence, which is what, people currently say. This is what most judges and prosecutors think. The role of the jury is only to evaluate factual evidence to see whether the person actually did what they were said to have done. Why would a jury of random people, why would 12 random people be better at that than a judge? Obviously, the judge would be better at that, right? Like, first of all, judges are generally more intelligent and more educated than random people by kind of a lot. And second, they have a lot more experience, like looking at cases. They're not going to get confused by DNA evidence, for example, because they're going to have seen it many times, things like that. So obviously, a judge would be better if you just want evaluation of factual evidence. Okay, how about evaluating the law, like interpreting what the actual law means? No, obviously, judges would be much better at that than jury members. So then what could it be? Like, what is there that 12 random people could possibly be better at than a professional judge who has done this all his life? Well, the answer is keeping the government in check. If the government is abusing its power, then a professional judge who works for the government and was appointed by politicians is not going to keep them in check. It would be only average people who have to do that. So, like, that's the reason why we have juries.
You make a really good point. However, I wonder if you kind of undercut something you were saying earlier, which is it's really hard to imagine a situation in which the jury people are going to have corrupt ethics and they're going to vote not to convict and when justice demands conviction. But wouldn't the judges be similarly corrupt? Not necessarily, because as you pointed out, they come from different social strata, probably they have different levels of education and probably intelligence. And so it could easily be the case that, jury nullification could make things worse.
Yeah. Yeah. I guess I was saying, yeah, I was saying before, oh, well, you have a racist society, so they're going to elect racist politicians and then they're going to appoint racist judges. They're going to make racist laws. You might think, oh, yeah, but maybe the masses are more racist than the elites, which is the case today. Although I don't think it was the case before. I think it used to be that the elites were equally racist. And they might have even been driving it, like coming up with their racist theories or whatever. Yeah. Okay. So, yeah, there is a possible situation where the elites, like the judges, would be protecting us against whatever, some really dumb, right? Really dumb values. That is true. But, they're not going to protect us against government abuse of power. Okay. So then you have to think, oh, well, what's more important to us? I believe there probably were cases, like people say this, that there were cases in the past where basically people would get acquitted of hate crimes because the jury were assholes. Like, because the jury was sympathetic to the hate crime. I don't think that would be happening today, bearing in mind that the jury has to have a unanimous verdict. I think it would be a lot harder today to get agreement on the racist thing.
Well, why would the jury necessarily be more skeptical of the state? I mean, if you've been in the system and you see how the sausage is made, you might be much more jaded and skeptical about it than, 12 randos who see, you know, TV shows that kind of, I don't know, glorify the system and they
Yeah.
kind of have the whole Stockholm syndrome thing about the state that you talk about. It's not clear that the jury people would be better at that.
Yeah. Well, it's not clear a priori, but it's true in fact. People who join an organization, it's just very widespread. Like, doesn't matter what kind of organization it is, they get a huge bias in favor of that organization. So, I like to give examples of this, although it's a bit of a digression. But, like professors are just like biased towards professors. They're biased towards the school and the academy in general, and their own department, right? So, like people in the philosophy department think that their job is to direct as much resources to the philosophy department as possible. There's a I I like to tell this anecdote. I was in the department meeting. This was many years ago, and we were talking about like there was money available for helping to integrate technology into our teaching. Okay, and then so the department chair asks whatever the technology represent the department's technology person, can you think of ways that we can do this? And he says, well, I can think of ways that we can better integrate technology into our classrooms, but none of them cost any money. And the department chair says, well, can you make them cost money? So anyway, this is just illustrating the idea that, yeah, we just want as much resources directed to our group as possible. Okay. But so if it's like us versus other departments, we want the money to come from other departments to us. But if it's other universities versus our university, we want the money to go to our university. If it's universities versus the rest of society, we want money to go to universities. It's just like that. And if you work for the government and, it's the government versus the people, then you want more money to go to the government. Okay. And just like even, and by the way, this is like, even though we've all seen, like, if you work in the academic world, you've seen the bullshit that goes on in the academic world, but you still prefer your bullshit over other people's bullshit.
Well said. I guess I want to turn to the question of individual ethics here, which is this is another point of hesitation. Like, I'm not sure I'm completely convinced here. And my thinking is that, like, well, there are certain roles where they constrain us in ways that I think help us achieve just outcomes. And because it might be a useful strategy, like fixating on a particular constrained role might be a better strategy for achieving the ultimate moral ends than directly aiming for those moral ends. So, what would be an example? I guess you hear this in academia. A lot of people are like, yeah, professors should be making students have the right political views because that would be better. You should aim directly at justice. If you're a literature professor, then your goal is not to teach Shakespeare or whatever. Your goal is to make your students have the right views and vote for the right politicians. And okay, and I don't think this usually works, but I think there's something pernicious about that. Often we can achieve more good by staying within our lanes and fulfilling like a narrow and less glamorous role that we are in. And it might be that that's the case for juries. I mean, you might still be right on the empirical side of things, but I just want to say I think there's some conceptual space for thinking about institutional roles where it's not like you're choosing the institutional role over justice, but you're seeing the role as part of a
Yeah.
general strategy for being more just, in the long term.
Yeah. Good. Yeah. So you could potentially have sort of moral dilemmas or just moral tensions where there's a tension between trying to do justice in this individual case and then like following rules or adopting the role that you think would be in general better. That could happen, and then it could be puzzling how to resolve it. But I don't think that happens in this case. Because in this case, I think the role and the rule would that would have the best consequences would be for the jury to exercise their moral judgment. Like why would that not be the best? And you think, okay, well, I don't know, maybe the legislators know better than the jury. I mean, some of the cases would be the jury disagreeing with the law, but some of the cases would be the jury just thinking, no, this case has unusual conditions. So, and the legislators, like even if they're smarter than the average jury member, they haven't seen this case. They didn't know about this case when they wrote the law, right? Because it hadn't happened yet. And the jury has had to sit there listening to all of the details of the individual case. So like they're better positioned to judge what is the just outcome of the case. Right? By the way, I have like one of these cases that I think was illustrative. There was a case where there was a anti-child pornography law, right? Like it was illegal to distribute child pornography. Okay, and so a young woman got charged for felony distribution of child pornography for sending pictures of herself to a boy at her school because she was underage, so it was child pornography. Okay, so it's not that it's an unjust law. Like, yeah, child pornography is bad. You should not be able to distribute child pornography. But like, you should think, yeah, but that's not what we meant. But the legislature didn't think of that case. So if you're there, and now whatever, I think the prosecutor dropped the charges, but only because it started to seem like the judge was super unsympathetic to the case. Okay, but if you just read the text of the law, it looks like, yeah, she violated the law. Okay. And like this, so if that had gone to trial, you would want the jury to say, no, but this case, like that person shouldn't be punished, right? Given the details of this case.
That's a good case. I wonder though. I wonder whether there are cases that would incline us to the other direction too, though. Like a case where there's some rule that it's really important society wide that we have it, but enforcing it in a particular case is going to seem like I don't know. You're gonna seem like a jerk. But but you have to do it. The defendant is likely to seem very sympathetic, but nonetheless, the rule is really important. So I can't think of a law like this right now, but I do think about certain anti-plagiarism and anti-cheating norms, um, and stuff like that, like with my students. And I don't want to enforce them, but I don't also want to be vulnerable to, my how I feel in the moment that the student is like crying in my office or whatever. I want to stick by the solid rule. The rule is established by someone other than me, so I'm not really responsible for that. Let the honor council
Yeah,
deal with that. So I wonder if there might be
yeah, good.
legal analogs to that kind of case.
Well, I mean, like what you raise, like that might be the reason why when you're designing the institution, you should take it out of the instructor's hands. Like maybe you should have a policy that the instructor has to punish the plagiarist. And then, like if the instructor wants to not do it, like he has to do it. Otherwise he could get in trouble. Right. And then, well, so could there be something like this in the case of jury trials? Like, well, okay, maybe the defendant could play on the jury's sympathy, but it seems like, well, the prosecutor could make this argument, right? Like, oh, this rule is really important. Okay. And then you might think, yeah, but what if the jury is, they're not rational or whatever, they're not appreciating the argument? Okay. But if you're talking about the design of institutions, like what should you have more confidence in? Like these are 12 people. Juries take their job pretty seriously. They're forced to sit there and listen to all of the arguments for like hours and hours, right? All the arguments that both sides want to present. Like, how could you be in a better position? Like they're in about as good a position as a person could be. So it is true that then they're still fallible because human beings are always fallible, right? But it's not clear that there's a better institutional design, right? That reduces the fallibility.
All right. I want to move on to something you bring up, and I don't think you come to like a completely fleshed out view about this, but the Gideon case, you have a right to no, yeah, a right to a court appointed lawyer, right? Yeah, so you make the point, and you're surely right that whatever principle, like it just seems like this was a case where a guy was accused of robbing a pool hall and he couldn't afford a lawyer and he was convicted and then he appealed this to the Supreme Court and they said, yeah, the conviction should be overturned. He should be given a new trial with a lawyer, and with a lawyer he won the case and was acquitted. And so now you have a right to a court appointed lawyer. But we all know that like court appointed lawyers are not the cream of the crop, you know. And
Yeah.
so you're not maybe being protected as much as you ought. And I can think of cases where people sue universities in particular, and they can just dip down into the state, like the state budget, not even the university budget, the state budget.
Yeah.
One of my listeners will be going through one of these things right now, and they just have endless
Yeah.
resources. So that doesn't really seem like justice either. So what
No, yeah.
exactly is required
But-
for justice? I actually have no idea what. what
So, yeah, by the way, like, I mean, so the court appointed attorneys, the public defenders, um, they might be sort of like not the best defense attorneys. Maybe that's why they're doing it because, like, that's the less lucrative jobs. Okay. But it also might be that they're sort of ideological. And I mean that in a good way, not a bad way. Like, they're doing it because they believe in the rights of defendants. But even so, even if they're super good, they have huge caseloads. So they're just forced to plead out most of the cases. And like just like much bigger caseloads than ordinary defense attorneys. The ordinary defense attorney can afford to give a lot of attention to you. Okay. So yeah, so you're just not going to get the same kind of representation. So, yeah, what does justice require? Okay, it's the government's job to ensure that justice doesn't go awry. And if that requires that the defendant have a high quality lawyer, then the government has to make sure that they have a high quality lawyer. And so, it looks to me like, well, they have to pay for like a private attorney, like a regular private attorney. And not somebody who has like whatever 50 cases that they have to deal with simultaneously.
Okay. Um, so in that kind of a case, yeah, a private attorney, do they have to see to it that you have an attorney who is by some metric evenly matched with the prosecutor?
I mean, he has to be good enough, right? Yes. good enough that he would probably bring forward the evidence if there was good evidence of your innocence, right? By the way, this reminds me of part of why we have this, the right to an attorney. Part of the argument was, yeah, so the argument was, well, you're not going to get a fair trial if you don't have a lawyer. And there have been academic studies of this indicating that you get better outcomes if you have a lawyer. Although the main reason for this is that the lawyers have more knowledge of court procedures, because these pro se defendants, they can read about the law online, but they don't have any experience with courts. So anyway, but okay. But anyway, like one of the arguments was, Clarence Darrow, the most famous defense attorney in history, was like widely reputed to be maybe the best or one of the best defense attorneys in history. When he was accused of a crime, he hired a lawyer. So if Clarence Darrow can't defend himself, then you certainly can't without a lawyer. So you're muted.
He wasn't even co-counsel.
I don't think so.
Yeah, that certainly seems right. So, is anyone proposing this, that there needs to be a bill that limits the caseloads? Like you just are going to have to hire a bunch more public defenders so that they have half the caseload or something?
Yeah, I've not heard of anybody doing this because Americans don't care about defendants.
Well, so why is this connects to a previous podcast of ours. We've got this Black Lives Matters movement, that is worried about police violence and Black people in the criminal justice system. Wouldn't the people they're concerned about be very well served if they got better defense at trials?
Uh, Maybe. I don't have a very high opinion of like the BLM protesters and their rationality, right? And their commitment to actually helping Black people. So like I think they're more interested in posturing as wanting to help Black people than in actually helping Black people, right? Okay, but now for your question, like, oh, would it help Black people? I mean, a little bit, right? Because let's not be naive here. The vast majority of defendants are guilty. Vast majority of cases end in conviction, and that's because they're guilty. Not all of them, and I would guess maybe 5% of convictions are wrongful. Nobody really knows. Okay, but anyway, so if you gave better defense to defendants, sometimes it would help guilty people get off, and that would be bad for the community. It would be bad for other Black people because most crime is intraracial, right? It's mostly people victimizing other people of their same race and in their neighborhood. Okay, so actually it would be bad for them. But okay, but then maybe some innocent people wouldn't get convicted. Okay, but then also the main thing that would happen, I think in most cases the same outcome would occur, and it would just be more expensive. And you think, okay, oh, so that sounds bad. So why are you advocating that? Well, you have to take higher expenses in order to protect against the rare but real cases of wrongful conviction. Like it would be a small minority, very small minority of cases, there would be an improvement with respect to justice, and in most cases, it would just be more expensive, which is why it's not happening, right? Because we're not willing to spend the money, to make the system more just.
Well, so if you had this reform, it would also make prosecutors have to be a little bit more diligent and maybe a little bit more selective about what cases they were going to prosecute. And so maybe there would be some good effects from that as well.
Yeah, that's right. Yeah. I mean, like I mentioned about the reason why we have the presumption of innocence is partly because it's worse to punish somebody wrongfully than to fail to punish somebody correctly. Um, but another reason is if we didn't have the presumption of innocence, then prosecutors and police would be lazy, right? They would just they would investigate until they thought they had a preponderance of evidence and then they would stop. So because we have this high threshold for evidence, they do a lot of investigation to collect a lot of evidence to make sure. And that's what we want.
That's interesting. Well, I guess before we go, I wanted to ask a bit about this. You had this interesting chapter on the price of law and how freaking expensive it is. I guess maybe second only to medical care, something that's super expensive in the U.S. compared to other countries.
Yeah. And university education.
Yes, but you get so much for that money.
Yeah. Good. Fair point. Yeah.
If you're in one of our classes, you get so much for that money.
Yeah. Yeah. Or, other people's classes, you get propagandized, and you get to know the truth about social justice, truth in scare quotes.
So you make a pretty compelling
Mhm.
argument that the expense of law is itself an injustice that I think is pretty compelling. So why don't you lay that out for us?
Yeah. I mean, one of the things is, well, it results in some people not getting it. And this is like one of the core functions of the government. Even if you're like, if you're a libertarian but not an anarchist and you think the government has some functions, this would be this would be one of the functions to provide justice, to provide dispute resolution, right? Because you don't want people resolving their disputes personally. You want a neutral arbiter, okay? But you can't do that if it costs like $50,000 to have a dispute resolved by the government, and the amount in dispute was $30,000 or something like that. By the way, like I've heard like this is a way to get away with not paying your bills, right? Just not pay, and then you could just say, "Oh, well, sue me." Right? And if the bill is less than $20,000, then it's not worth it to sue you. But anyway, okay. Okay. So the first thing is like, yeah, they just don't do their function, so they don't resolve disputes, and they're obligated to do so. Okay, so then like there's a lot of people who can't get justice, like wrongs have been committed against them, and they can't get anything done because they don't have the money, or because the amount that it would cost them would be more than what they would get out of it. And then the other problem is, oh, that it just constitutes like a punishment that you suffer no matter what the outcome of the case is. So, like, if you get prosecuted for a crime that you didn't commit, even if you get the right outcome, so you might not get the right outcome because maybe you can't afford, like, Johnny Cochran or the best defense attorneys, and like, oh, maybe you would, maybe you would get the, maybe you would get acquitted even if you're guilty if you have the right lawyers. But anyway, you know, okay, even if you get the right outcome, you still had to pay tens of thousands of dollars to defend yourself, might and spend all this time in court also, right? Which is, an additional problem. But anyway, like
It
if
seems
you
to me like if I am accused of a crime I didn't commit and I spent tens of thousands of dollars defending myself and it took weeks or months of my time and it put all this anxiety and pressure and mental anguish on me. It seems like I'm entitled to some compensation for that, right? Why not?
yeah, yeah,
I did nothing to deserve any of that and was
yeah,
compelled to by the state's power to impose an unjust,
yeah,
you know, prison sentence on me. It seems like I'm owed some compensation for that.
yeah, that's right. So, like okay, if you made this argument in court, I anticipate that the court would say, no, because, the government didn't do anything wrong because they had evidence that you were guilty. They weren't being malicious, hopefully. Although there are cases in which, they are malicious. But anyway, so hopefully it was just a mistake. So they didn't do anything wrong. So they don't owe you anything. Okay. But okay. But, my point of view is no, but they're obligated to not punish you unjustly for a thing you didn't do. So, and having you pay $50,000 or whatever, that's a punishment. And if you didn't do the thing, it's an unjust punishment. And okay, and then they would say, "Oh, no, no, it's not a punishment. It's just like, you're just paying for a service." No, but the government forced you to pay for that service because if you didn't, they were threatening to unjustly punish you. And they have an obligation to not unjustly punish you. So, uh, they can threaten to do stuff that they have a right to do, and then you wouldn't be owed compensation. But they can't threaten to do stuff that they have no right to do, like punishing you unjustly, which is what would happen if you didn't have a lawyer. And you might think, oh, but why should the taxpayers have to pay for this? Because the taxpayers didn't do anything wrong. I guess another argument you might make, like, yeah, yeah, sure, you shouldn't have to pay, but other people also shouldn't have to pay. Yes, but if you make this argument, then that means the government should never have to pay for any lawsuit. Anytime you should never be able to sue the government. Presumably, we don't want to have that result, right?
Yeah, that seems it's like fairly compelling to me, that reasoning you've just laid out. So, yeah, and if they did have to pay, presumably they would be more selective in what cases they brought to trial.
Yeah, they would try to not do this to innocent people. They would try harder. They would have more incentive, right?
All right. Well, we've been going for a good while now. Is there anything else you wanted to add?
Just like people should buy the book because there's lots more stuff in it. There's a lot more issues that we didn't have time to get to.
Very interesting book, very engaging and well written as always. It belongs on your bookshelf besides all of the other Mike Huemer books that I presume that you have bought by now.
That's right. That's right. all of my books.
All right, Mike, thanks so much for making the time.
Thanks. Thanks for having me. Always great talking to you.